Morning, everyone. Welcome. This is Estate Administration, Understanding the Process. It's going to be a guide to the probate and estate settlement process. My name is Glenn Bates. I'm an attorney with Woods & Bates in Lincoln, Illinois. My info is on the screen there. You can contact us by phone, by email. Our website's at the bottom there, woodsandbates.com. So I want to go through this process with you today. And one of the reasons that we want to go through this process is it's likely that most people, if not all people, are going to experience this process at some point, whether it's death of a loved one, being a beneficiary of an estate, some way, shape, or form. This estate administration process is going to touch the lives of many people, and it can be complex, it can be stressful if it's misunderstood. So we want to shine some light on some facts. There's a lot of misinformation out there. So I think the more that we can understand the process, the less misunderstanding there will be, and the less frustration, hopefully less litigation, less fighting. There is a legal disclaimer on the screen there. This is just informational only. It's not to be considered legal advice. If you need specific legal advice, feel free to let us know, let another attorney know, and we can give you some guidance on your specific matter. But this information in this presentation is just general today. So I want to talk first about what is the estate of the deceased. Okay, so there's some language that we typically use. We talk about a gross taxable estate, and at the top of this chart here, you'll see that the gross taxable estate consists of everything that the decedent owned at the time of their death. We differentiate in our world between what we call non-probate assets and probate assets. Okay, so non-probate assets are assets that did not go through the probate process. So those are not going to be controlled by the court process that we're talking about today. That includes things like assets that have joint owners, assets that list beneficiaries, payable on death designations, transfer on death designations, those types of things, and any assets that may be owned in trust. Those assets owned by a trust would go to the trust beneficiaries or be held by the trust, depending on what the trust says. Assets that list beneficiaries, payable on death, transfer on death, are going to go to those specific beneficiaries that are listed without probate. And then any joint owner with rights of survivorship is going to automatically own that asset if one of the other joint owners dies. So what we're left with then is what we call probate assets, and those are assets that the deceased owned only in their own name. They don't have any joint ownership, they don't have any beneficiaries, and they aren't owned in trust, they're owned outright. And those are the assets that are distributed through the probate process. So those are the assets that are controlled by a will, if there is one, if the deceased had a will. And if the deceased did not have a will, those assets are controlled by intestacy laws, is what they're called. Those are the laws of the state of Illinois that say here's where your things go if you don't dictate where they go in a will. So we're going to have will beneficiaries that are going to become important, and we're going to have what's called heirs at law. And our heirs at law are those beneficiaries that would inherit in the absence of a will. So if somebody did not have a will, the heirs at law are going to be outlined in the statute. For me personally, my heirs at law would be my spouse and my children. That can be different for everybody, but the statute says who those people are, and it will tell you if you need to know. So when we open an estate, one of the first things that we do is we'll ask the client, do you have the original will? And once we have our hands on the original will, we will take that original will to the courthouse. That will is to be deposited in the courthouse in the county of residence where the deceased lived upon their death. That is supposed to be done within 30 days of date of death. That doesn't always happen, but that's what the law says. In the real world, there is no real formal reading of the will, anything like that. We will read through the will with the client that brings it in if they don't know what it says. Most of the time they know what it says. They know who the beneficiaries are listed in there, those types of things. But when we read through that will, we'll see, okay, who's listed, whose information do we need, whose names, addresses, telephone numbers, those things to contact them. A will in our state is assumed to be valid unless it's contested. You know, there's several reasons you can contest a will. You could say that it's not in proper form. You could say that the person that signed it was not of sound mind. You could say that somebody was putting undue pressure on them to sign it at the time. But unless somebody contests that will, it's considered to be valid. Now, there's only certain people that have what's called standing to make that contest. We'll get into that a little bit later, but there are certain time frames within which they have to do that as well. Once we have the will on file, we file several documents with the court on behalf of the nominated executor. So that will likely nominates an executor to act to deal with this probate process. That executor is going to petition the court and ask that they be appointed. If there is no will, someone will petition the court to be what's called an administrator. They do about the same thing. It's just a little bit different process. There are priorities given to certain people in the laws as to who can act as administrator, who has preference to act. And we can get into that if we need to. But if the will says this is who I nominated as the executor is going to be the one that's going to file documents with the court, assuming they want to act. So that first document we're going to file is called the petition for probate of will and for letters of office. There's a form of that example document on the screen there. This is the first page of that document. So what that document is going to say is our nominated executor, Jane Doe in this case, is petitioning on behalf of the estate, and in support of this petition, she's outlining the information about the deceased. So John Doe was a resident of Easy Street in Lincoln, passed away on January 1st, 2022. He had a will. That will was dated September 15th, 2010. We believe that's the valid last will and testament. So our petition is going to also outline the values of the decedent's assets that they had in Illinois. And these are probate assets, so personal property, real property, and then any income annually from the real property. After we do that, we're going to outline who are the interested parties. So our interested parties in an estate proceeding are going to be any of the heirs at law, which we talked about earlier, and any of the beneficiaries or legatees under the will. Okay, so all of those people are going to be named. The relationship, the decedent is going to be listed. Whether or not they're an heir, a legatee, or both is going to be stated, and then their addresses are going to be stated. Okay. The people that are listed in the petition are the people that have standing. Those are the people that are entitled to notices. Those are the people that are entitled to get involved in the process if they want to, and they may or may not take assets from the estate. It's possible that an heir could be a legatee, so an heir could be listed in the will as a beneficiary, but an heir need not be listed all the time. So they could just be an heir. They may not take anything from the estate when it's ultimately distributed. In order for the judge to be able to figure out who the legal heirs are, the next document we file with the court is called the affidavit of heirship. And so in that affidavit, somebody is stating under oath the legal heirship of the deceased. Okay, so again, in this case, in our example, Jane Doe is stating that John Doe was a resident of Easy Street in Lincoln. They have knowledge of what they're stating here. So Jane, in our case, is a surviving spouse. She's saying that her husband passed away January 1st, 2022, that he was only married to her during his lifetime, and that their marriage produced two children, Johnny and Jessica. They're both adults in this case. And she's saying that her husband did not have any other child or children born or adopted during his lifetime. That being the case, pursuant to the statutes, we don't have to go any further. We don't have to trace his lineage any further because we have established now his heirs at law. His heirs at law are his spouse, Jane, and his two children, Johnny and Jessica. Okay, so Jane is also going to submit to the court an oath Sometimes that oath has a bond associated with it. This particular example does not, because we have a will. One of the advantages of having a will is that it waives the bonding requirement. So we have an oath of office that Jane's going to submit. She says she's going to faithfully discharge the duties of office of the independent executor of the estate. And so she's going to file that. We're going to file that on her behalf with the court as well. So what's going to happen is those documents get filed, those documents make their way to the judge's desk. He takes a look at those and satisfies himself that those are all correct and that we've done what we were supposed to do. We established the legal heirship, and based on the legal heirship, our petition is correct. The judge is going to enter some orders. He's going to declare the legal heirship of the deceased, and he's going to enter an order admitting that will to probate, and he's going to appoint our nominated executor, hopefully, as the executor of the estate. That file then is going to make its way to the clerk's office, and the clerk is going to issue what we have called here letters testamentary or letters of office. This letters of office document indicates that our nominated executor, Jane, has been appointed as the executor of the estate of John, and she is authorized then to take possession and collect the estate of the deceased and do all acts required of her by law. So we request in Illinois, most typically, almost all of the time, we request what's called independent administration. So once that independent executor is appointed or the independent administrator is appointed, they are vested with the authority they need to go out and wind up the affairs of the deceased. So if they need to obtain appraisals, they need to sell assets, they need to liquidate assets, they need to secure assets, whatever it is they need to do, they're vested with that authority when they get these letters of office. So the clerk's going to date that, they're going to sign it, they're going to stamp it. We're going to get as many copies of that as we need for that executor to go out and do those things. All estates are not independently administered. Some are supervised by the court, but the independent administration makes it a little easier for that executor to do things so that they don't have to ask the court's approval to do it. So if we want to sell real estate, we don't have to petition the court and say, Judge, we'd like to do this. We think it's reasonable, and get authority from that in independent administration. If for some reason the case became supervised or it needed to be supervised for some reason, we would need to ask permission to do those things as we go. But I'm assuming independent administration as we go along here today. Okay, so our executor has been appointed. They have their authority, they have their letters of office, we have death certificates. One of the next things we're going to do on behalf of the executor is get what's called a employer identification number or a tax ID number. That is going to establish the entity of the estate for purposes of opening an estate bank account, filing any tax returns that may need to be filed. And the way that we do this is we ask the executor to sign Form SS4 from the IRS that authorizes us to obtain that information. We get that number, we give that number to the executor, and then they can go out and open their bank account, get started on their way. So once the executor or the administrator has all of the documentation information that they need, they have certain requirements under the state statutes to administer the estate. So one of the things that they have to do is they have to send notices to heirs, beneficiaries, and creditors that that estate has been opened. So we know now who our heirs at law are. We know who our beneficiaries are. Those people are named in the petition. Their addresses are in the petition. We're going to send them notices that say, this estate's been opened. You have certain rights as an heir, as a beneficiary. Here's those rights. You have the right to contest the will if you want to. You have the right to terminate independent administration. Here's a form that you can do that on if you want to. So we send all those notices out. We also have to notify creditors of the deceased that we know about. So if we know someone is a creditor, we send them a notice as a known creditor. That executor is going to go out. They're going to manage real estate, financial accounts, whatever it is they need to do. Maybe there's some keys out there. Let's change the locks on on houses, do what we need to do to secure those assets. We're going to pay debts, we're going to pay taxes, handle any disputes. So if somebody calls and says, you know, I don't like the way this has been done, the executor is going to handle that with our assistance, and any legal matters that come up along the way. So ultimately what we're going to do is we're going to distribute any of the remaining assets to those beneficiaries from the estate. Okay. Some of the other notices that go out, there's legal notification that has to be sent to interested parties, which we already talked about, but there's a notification that gets published in the newspaper. That notification is to be published once a week for 3 weeks in a newspaper of general circulation in the county of residence of the deceased. So once that first publication notice appears in the newspaper, any unknown creditors, so creditors we may not know about, have 6 months from that date to file a claim against the estate. So they could send a claim to the executor, they could send it to the attorney for the estate, or they could file it with the court and send a copy. But they have to do that within 6 months. If they don't do that within 6 months, they're barred. So that publication notice speeds that up. By statute, that is a 2-year window. But when we publish that notice, it speeds up that window to 6 months. If we do get claims that we believe are invalid, we can dispute those. Believe it or not, that does not happen very often. Okay, so some of the other things our executor is going to do along the way is we're going to make a listing or an inventory of all the assets that the deceased owned. We're going to provide that inventory eventually to all of the beneficiaries, all the interested parties. We talked earlier about probate versus non-probate assets. This is going to be an inventory of the probate assets. It's possible that the executor, I mean, somebody has to deal with the non-probate assets also. That may be the same person that's nominated as the executor. It may not, but somebody may need to do things like make claims on life insurance, deal with jointly owned assets, those types of things. But if need be, we're going to obtain appraisals for any of the real estate that we own, that the deceased owned at the time of death, and any personal property that needs an appraisal. Some doesn't, you know, bank account, we know with certainty what the value of that account was on date of death. We just need a printout of that, and that tells us what the value of the asset is. Something like a farm or something like farm equipment that may require an appraisal, which is a valuation by somebody that's licensed to do it that says this is what that's worth. Those appraisals do several things for us. One of the things they do for us in the estate is they establish value so that we know what the total value of all of the assets of the deceased are. Illinois has an estate tax exemption amount of $4 million. So if the total value of what the person owned at their date of death, including probate and non-probate assets, is above that $4 million, there's a requirement to file an estate tax return. If it's below, there is no requirement to file that return. So it gives us that value so that we know whether or not we have an obligation to file those returns. Gives us the ability to value things for purposes of distribution. It also provides us with a value for cost basis for beneficiaries. Beneficiaries still have the added benefit of getting a step up in basis to the value of the asset at date of death. So they don't take the deceased's cost basis. Their cost basis moving forward will be the value at date of death. So those appraisals establish that for us. Those are always good to have. Those are always good to hang on to for the long term, because those are the documents that establish those basis figures as well in the future. Could also establish value if we wanted to sell something. You know, we want to sell this, but we don't know what it's worth, what we should sell it for. Okay, here's an appraisal. That gives us an idea. Sometimes in an estate, when we get to the point where we know what all the claims against the estate are, we know what all the debts are, we know what the assets are, we know what's there, we know what's due, and what's there is not enough to pay what's due. So if there are not going to be assets left over, if there are not enough assets to pay the debts, those claims or those debts get classified according to statute depending upon class. Okay, so the statute has said there's 7 classes of claims. First class claims get paid first, and then you go down the line and pay each class of claim until you get to a class where you don't have enough money. That class gets prorated, and then anything below that class doesn't get anything. So for instance, if we have not enough money to pay all the claims, we look at those claims and we classify them. Class 1 claims would be funeral expenses, burial expenses, costs of administration, attorney's fees, things like that. So if we have enough to pay all those, we pay them. Then we go to class 2 claims, surviving spouse award and child award. If we have enough, we pay those, so forth, all the way down the line until we get to the point where we can't pay them anymore. Then we prorate those. What it's called when we can't pay all the debts is a insolvent estate. If we do have an insolvent estate, we would typically ask the court's blessing before we make those distributions to say, here's what we have, here's how we're proposing to distribute them. Please approve that for us so that the executor doesn't get into any hot water by just unilaterally doing those things. If we have enough money to pay those debts, once we get past the 6-month claim period, we pay them, and then we have to make a distribution. That distribution can be made in one of a couple ways. Usually what we do is we say, here's an accounting of everything that came in. Here's what we paid throughout the course of the administration. Here's what's left. Here's what's left to pay. And here's how we're proposing to distribute the rest. If you agree with that, beneficiary, please sign this document, say that you agree with it, and we will write checks and distribute all the assets of the estate. If we can't get agreement from beneficiaries, again, we'll ask the court to approve our proposed distribution. That's infrequent. Usually we get agreement. Usually everybody's on the same page. It's much faster when we get agreement, but if we need to involve the court, we can do that as well. Once we have everyone's agreement or we have a hearing set, we will file a final report with the court. That final report says we've done everything we're supposed to do. We've paid the debts. We've made the distributions. We're asking that the executor be released from their obligations at this point. We've done everything according to law that we were supposed to do. If there is a need to file income tax returns, the executor can do that on behalf of the estate. Sometimes there's income that comes in during the administration, sometimes there's not. And then there's going to be orders that are entered by the judge again that closes the estate, releases the personal representative, and says, that's it. This case is done. We've done what we needed to do. And that brings the court case to a close. Some of this can be complex. It can be time consuming. It can be stressful. Just as a informational, it can be avoided. And there are schools of thought that say it should be avoided at all costs. Okay, so this chart kind of gives us a pros and cons of having a will versus having a trust-based plan. So one of the advantages of having a trust-based plan is that we avoid probate if the trust is funded correctly. So if our assets are all owned by the trust, they're all going to fall in that non-probate asset category, and we're not going to have to probate the will. We're not going to have to go through the process that we just talked about. So one of the benefits of having a will-based plan only is there's a lower upfront cost, lower time commitment. What we're saying is, here, executor, go do this when I'm gone. But there's no control of your assets during your lifetime with a will, whereas there would be with a trust. The trust is going to have some higher upfront costs because you're establishing that while you're living. You are retitling assets into the name of the trust, so there's going to be some increased time commitment to make sure that that's adequately funded. However, after death, there is that court involvement that we just talked about with the will. There's not with the trust. That will is admitted to probate, that executor is appointed, that executor is going to be the one that gathers the assets, distributes those assets. Some higher costs because it's more time consuming at that point. Could be some delays. We have some delays with built into the statute. We provide a notice and then there's a 6-month claim period. So there's going to be at least 6 months where we're telling the executor, you don't want to distribute anything yet because you don't know what the claims are. There could be claims made against the estate. So that's also a public matter. If you wanted to, you could go over and pull the probate file and look at that. That's important to some people that they maintain privacy, which they can do with the trust. There's no court involvement with the trust. The successor trustee in the trust is the one that has authority of what the trust owns. They distribute the assets according to the trust. If we've done it correctly while you're living, there should be minimal cost, minimal time commitment, and no delay. It happens automatically without court involvement. And those trusts, again, are private. So I guess in conclusion, the estate administration process is a very structured process. It's a legal process. The statute says these are the steps that you have to take to probate a will to get through this process. These are the notices you have to send. Delays and disputes can arise in a probate process. Professional guidance from attorneys and advisors is key to making sure that these are done correctly. We would be happy to help with any of these things. Our telephone number is going to be on the screen soon. I appreciate everyone joining us today. If we can be of assistance to you, our information is there, and thank you.